But we have a great program here today. And if you haven't looked in your program, and I'll introduce Jim Beaupre in a second, read the program. And if you read right under the program what it says about the rules that are coming out, consider not being in compliance and being liable to the government for all contract dollars collected to date times 2. If that doesn't encourage you to listen up, I don't know what will. So let me turn it over to Jim to introduce his panel. Thank you.
I want to introduce Ken Dodds, who's from the Small Business Administration, and his office is actually, we're really privileged to have him here today, because it was his office that helped generate these rules. And they've been 4 years in the making? 3 years. 3 years. Oh, only 3 years, you know. You know, considering Congress, that's lightning speed.
Right.
We're supposed to have a seat. Have a seat. We're supposed to have Rob Burton here. Has he shown up? I guess not. Rob from Venable. Well, let me give a little background, and I might invite somebody else up here. So this program came about because recently the University of Virginia, Mary Ann invited me to a session that they were having at their school, and there was about 20 people there. And what the discussion was about 3 new rules that have actually come out of SBA this year that could become part of the FAR. That's the goal, right, Ken? And when I listened to them, we talked for an hour and a half, Marianne, because some of them for small businesses and for large businesses could be a bit scary. And as Jim said, you really ought to pay attention. I have the 3 rules here if you'd like a copy of them. But they involve, first of all, they involve some acquisition issues. But second of all, they involve what to do about sizing. With regard to sizing, that you would think, oh, okay, I'm a large business, and what do I care what a small business says? Well, you'll learn that you should care when you have to subcontract with a small business. It also changes some rules with communications that could have a significant impact on how people deal with it. Still no Rob? Okay. Marianne, why don't you come up? Because Marianne was very much involved in this. So, Marianne, this is Ken Dodd. Marianne's with the University of Virginia, so I said we could talk about this. We were so excited the other day talking about this. Well, Ken, obviously, why don't we start with you and you summarize the rules for us?
Okay. Thank you for having me. I'm very glad I don't have to dance. I can't dance at all. So basically, the Jobs Act of 2010 created these various different. It's better now. Can you hear me now? Yeah. Good. The Jobs Act of 2010 created various things that had to do with subcontracting, multiple award contracting, and size and status integrity. And they all had different aims, and so we broke them into 3 rules that were finalized this year. SBA basically sets policy by making these final rules, and then we submit them to the FAR Council, and they put them in the FAR through the process of negotiation with GSA, DOD, and NASA, who are the people that the agencies that run the FAR. So these rules that I'm going to talk about will all make it into the FAR one way or the other, either in Part 19 or in various clauses. The first rule has to do, I guess I'll talk about multiple award contracting. Right. That's been something that's been going on a long time, where agencies were setting aside task orders for small business or reserving contracts for small business. So we kind of tried to flesh out what it means to do a set aside for small business in those contexts, what the rules should be, what kind of limitations on subcontracting would apply, for example. You know, when a small business does a set aside, they're supposed to do, 50% of the work generally if it's a service contract with their own employees. Those kinds of things we tried to address. With respect to size and status integrity, there are several provisions that Congress was clearly concerned about firms misrepresenting their status and getting contracts, small business contracts. I mean, there's been a lot of articles in the Post just recently about that. And so one of the provisions that they created was a presumption of loss equal to the value of the contract, basically. In the past, it had been hard to get the Department of Justice to prosecute for misrepresentation because if the firm performed, there really wasn't a loss to the government. Now the Department of Justice has a tool that says there's a presumption if you got a $10 million contract through misrepresenting your status, there's a presumption of loss to the government equal to that amount. So therefore, the Department of Justice may go after that firm to try to recoup that amount. There's various other provisions about if you submit an offer for a small business set aside, it's deemed to be that you're certifying that you're small. There's a signature requirement that we're going to have to implement somehow, basically where someone from the company has to certify to the size and status that they're claiming. There's requirements to update your status and the databases as well, at least on an annual basis. I think that's probably been there for a while, but it's now kind of part of the law and part of our regs. And so SBA had to then draft rules to figure out what it means to be, misrepresent your status. When will that be something that will be prosecuted? Maybe. When will it not? What if there's a technical malfunction, for example? What if there's the government misrepresented your status, the company didn't? Those kinds of things are factors that we kind of listed in our rules. But ultimately, it's going to be up to a Department of Justice attorney to feel that he has enough of a case to bring that to a jury to make a decision about whether you misrepresented your status in a willful, knowing way.
So what's interesting about this particular law is that when it comes into effect, you're going to be expected to, as a prime contractor, if a sub certifies to you that they're a small business, do you take them for their word? And as prime contractors, you take on the risk in the event that they misrepresent themselves to you. So I think that's a sort of a challenge that prime contractors will be dealing with from a, how well do you know your subs? How well do you know what they're certifying to?
Yeah, I think there's still language in our rules that say, you can rely on good faith representations of subs. There has to be some kind of knowing willfulness to the misrepresentation, and I don't know that. I'm not saying it can't happen, but I don't know that we would hold primes accountable if a sub misrepresents something to them.
Oh, Rob, Rob, come on up. I'll stand. Yeah. No, you stay, Marion.
How you doing? Good to see you.
This is Rob Burton, good friend Rob Burton from Venable law firm, and I was telling you about that. We heard this session. It was two attorneys from Venable that actually gave us the discussion, and Rob. So, Rob, we were just summarizing the laws, the three new rules that came out of the Small Business Administration, and Ken, his office is actually the author of those rules. And we were talking about the subtleties of the rule that says the liability ones, and the issue with regard to if you're a prime contractor and you have some subs and they attest to their size integrity. But then what happens when you find out as the prime that either they misrepresented themselves or their situation's changed? What happens then? What are you supposed to do as a prime to not have liability?
That's a good question. I think for starters, I would not report them as a small business on your subcontracting plan reports that you submit to the government. That would be the first place I'd start, if you know that they're not small. There are avenues that we can protest someone's size. SBA, for example, can file a protest at any time with respect to a concern. So if they have a prime contract, we could do that. If they're in a database, for example, representing themselves as small, SBA can file a size protest to determine them other than small. We also SBA does compliance reviews of prime contractors to see, and that's another area of focus coming out of this rule is, are the representations that you're getting with your subcontractors, valid? Are they believable? Are you doing something to get some kind of representation, especially, for example, with respect to a NAICS code? What's the size standard that they're telling you that they're small under?
Correct, and it becomes a challenge because a lot of companies will have different NAICS codes that they're selling products and services under, and of course each NAICS code has a different statute or a different level of number of people and dollars associated with it, so it makes it a little bit of a challenge.
Rob, do you think there's more liability on prime contractors now, large prime contractors with subs?
Well, I mean, I don't know exactly. I apologize, too, for being late, but I don't know exactly what you've covered. But this is a huge paradigm shift with respect to prime contractor responsibility. I suppose everybody has figured that out. But there's enormous risk here for the prime contractors. And with respect to the particular question that you're asking, the large contractors now have to show good faith that they did their due diligence, they did their homework. I don't really know what that means. But I would suggest, at a minimum, it means you better have like really good internal controls. You had better amend your internal controls right now and your ethics program and your ethics code to get these new rules in there. You have got to show that you were aware of these rules, that you had a process for doing due diligence with respect to relying on the representations that these subcontractors make. I think it's huge, and I think and of course, there's a number of other obligations with respect to the prime contractors ensuring compliance with the subcontracting plan and so forth that the small business has presented to that prime contractor. So it's a new day. You know, this was when I was at the Office of Federal Procurement Policy. These were some real hot button issues way back, you know, in the mid 2000s and later, where GAO, Congress, everybody was very concerned about subcontractor representations with respect to size and status. And this is really an outgrowth of those concerns that were way back then. And so it's taken a while. It takes the government a long time to move. But that's what you're seeing here with respect to ensuring that small businesses comply with the prime contractors, to ensure that prime contractors comply with the subcontracting plans that they submit to the government with respect to meeting their small business goals and so forth. There was always concern that prime contractors played fast and loose, that they would get these contracts, these lucrative contracts, and had no intention of necessarily using the small business that they represented that they would. So that is a huge issue. And the primes are going to be, I think, held accountable more now.
Yeah. Just to bring us all up to speed, why don't you address the other two rules that came into effect, because we haven't talked about those yet, and then alluding to what your comments are.
Because you're alluding to the other rule.
Right,
yes.
and the subcontracting rule itself has implements statutory provisions that have to do with payment of subs, paying them late, and also has to do with not, using a sub to help prepare a bid or proposal and then not using them in performance. Basically, the statute says that if you have been paid, the subs performed, and you haven't paid them within 90 days, that the prime has to report themselves to the contracting officer. And the same thing goes for whether the firm was used to help prepare the bid, but not used in performance. You're supposed to report yourself to the contracting officer. The intent is that the contracting officer will then use that as part of an evaluation of how you performed on that contract. And in fact, if you have a history of making late payments to subs, they can enter that into the FAPIS, the Federal Awardee Performance Integrity Information System.
So one of the things that this means to contractors is that whereas before the privity of contract was always between the government and the prime contractor, there was a contractual relationship there, and there was always privity of contract between the prime contractor and the subcontractors. Subcontractors now have the ability to go beyond that relationship, go directly to the government and report if you're not paying them on time or if you're not using them to the fullest extent that you said you were going to be using them. So it's sort of a change in paradigm in terms of how business is actually getting run. And as prime contractors, you don't have the exclusive control over the relationship between what your subs can talk to the government officials about. They have the ability through this statute to be able to get to them.
Having been a small business many times, primes want to put in contracts and say, oh, you don't have the right to speak to the customer. Mm-hmm. They can no longer do that. There's a rule that says they can't do that anymore.
Right. I mean, we heard from all the subs out there when we were going around the country trying to create this rule. They said, well, a lot of our subcontracts say we can't communicate, and you can't have a self-reporting system without any police there, without an ability to communicate with the government. It would make it meaningless. So we specifically said in our rule that the sub can communicate with the CO about material matters such as whether you've been used in performance and whether you're being paid on time. Now, our rule, as I said before, has to be implemented in the FAR. Where are they going to put that provision? Is it going to be in a clause, in a section? How is that going to be implemented as we go forward?
And I think this is huge. Again, this is a huge paradigm shift. I mean, you always, as a subcontractor, knew you weren't supposed to talk to the government. That was sort of like rule number one. The privity contract rule meant something. So I just had a client recently who said, I can't take this subcontractor. I don't plan to use them. I mean, they're a pain in the royal rear. And basically, we had to position ourselves to say to the government, even though we had said we were going to use this particular subcontractor, we do not plan to do so now. So the subcontractor, of course, says, well, I got news for you. I'm going to the agency right now, and I'm going to turn you guys in and let them know that you were really bad people. So, I mean, this is really serious, because to the extent they have that direct communication, who knows what they say? Of course, they're going to make you out to be the devil. And to the extent that they would do a good job of it, it could certainly, well, I'm very concerned too about how it's going to reflect in your past performance rating. I mean, how's that going to work? To the extent the contracting officer listens to these folks, and to the extent they're persuaded that, boy, they really got a bum rap, it may show up in the past performance rating, even though there's no necessarily legal recourse, with respect to, you decided not to use that particular subcontractor, and I'm sure you have a reason for not using that subcontractor. But there's always going to be, because of that direct communication aspect, you don't really even know what's being said. You don't know exactly what that subcontractor is saying. It may not be true. And so the direct communication piece, I think, is absolutely huge, a huge paradigm shift.
One of the things that surprised us about, we'll get some questions. Oh, I see it's going quick. I told you this would go quick. What surprised me when I learned about this, I asked around in our community, it seems to have gone all over our heads. I don't know how we missed this one. Let me ask Ken one more question, then I'll open up for questions. Ken, there's also some subtleties on past performance and bids, and how past performance was considered and can be considered now differently, right? Yeah,
we tried to be, instead of a lot of the punishment stuff that Congress had given us, we tried to be more creative in terms of giving primes an incentive to kind of compete with each other in terms of subcontractor performance. So these are all discretionary things, but we said, well, why don't we create evaluation factors not just about how they propose the subcontract and not just about how they have performed in the past, but why don't we do something like evaluate to the extent which they paid their subs in a timely manner? Why don't we get them to compete somehow to give the government a commitment to pay their subs in a certain amount of time for the procurement? So just ideas that we're trying to get out there to get, the more that subs feel that they're not being treated fairly, the more they go to the Hill, and the more provisions that are going to come out. Even in the NDAA of 2013, there's a provision that says if you name a sub in your bid or proposal, you have to give them notice. Because, again, a lot of small subs feel like they're being used, their names are being put in proposals, and they're helping to win, and they're not being used. Whether that goes on a lot or a little, it's the perception out there that is felt.
And I think that's the critical part. A lot of things in government contracting, it's like a pendulum swing. So you've had large companies who have promised or made commitments to small companies and then have not used them over the life of the contract, or slowly squeezed them out, which wasn't fair to the small businesses. The government's had options. We've had contracting officers, for example, who have put in liquidated damages, that if you put the subcontracting plan in and you don't meet the goals of the subcontracting plan, you could have been hit with liquidated damages. But it was very sparse. It wasn't across the entire government. So now there's some teeth there, but what it's doing is it's changing the boundary between prime contractors, the government, and subcontractors, and that's the key message of this presentation.
I'm sure there's some questions.
So is it all subcontractors or small that are affected? Just small subcontractors?
Yeah, our rule is focused on small businesses.
The rules are around the SBA.
Right.
And it applies to contracts that are covered basically by a subcontracting plan. $650, I think, for services and $1 million for construction, or whatever the thresholds are. So basically, it'll apply to those larger contracts where you have to have a subcontracting plan. The intent is for it to apply to all of those. Right, the small business subcontracting.
Mike, you got a question back? We got one back in the back.
Just a comment and maybe a question inside the comment. I think one of the complications or unintended consequences from this could be that the large businesses in developing their teaming agreements with small businesses will be less specific at this point and non-descriptive of what they're going to give them, so there's really no way to complain about it. If the intent is to really make sure small business subcontracting plans that are being delivered in proposals are being met, I think there needs to be more teeth put behind the subcontracting plan and let the contractors figure out, the primes figure out how well their subs are performing and reward those subs for good performance to meet that 30% or 40% goal. I think the way currently written, I would see more unintended consequences in which the small businesses will suffer as opposed to benefit.
Well, think about the fact that the reason why the agencies push down the small business contracting objectives is because those objectives have been set for the agencies, and they need prime contractors to be able to support and meet those objectives because they can't meet them themselves. They need it through the prime contract vehicle in addition to whatever small set-aside businesses they have. So, you know, if we don't commit to how much we're going to be able to use them, then the government can't meet their objectives until after the fact.
What I'm saying is the problem, the large business prime will, I have my 30% subcontracting goal. I'll commit to it, that's not a problem. But if I'm reaching an agreement with somebody, I'm going to target roughly 10% of the contract over to you, and that company wants to use that to go complain that I'm not getting my 10% of the greater of the large employee. The large businesses are going to, they're already going to lose their agent. Most of them won't even steer towards a percentage of the community. And this is just one more nail in the coffin for those large businesses. If we need any kind of descriptive percentage into a work share, they'll just say, well, you're on the team and you can't commit.
I agree with what you're saying. It could be, it's going to have a significant impact on teaming agreements between primes and subs. But the fact is, what Ken said, also written in here, is rules on evaluation. So you're going to have to be careful if you could be evaluated negatively if it's not a good, strong teaming agreement in the proposal.
And it's not so much one company, like if your whole organization isn't meeting the 30%, I don't know that the law has been that specific to say, okay, company A didn't get the 10% they were promised as much as it is the whole group isn't meeting.
Right, I mean, before this statute came out, I mean, if you're the government, you just want to meet the 30% subcontracting or whatever the goal was. You don't care if it's company A, company B, company C. Usually, now you might really want A, B, and C, and that's certainly how the small business subcontractors portrayed it, which is why these laws were put into effect. I mean, there may be unintended consequences, but the Congress has been convinced that they're using these subs to get the contract and not using them in performance, and this is the result of that. With respect to the liquidated damages thing, that's always been a problem because as a contracting officer, you'd have to make a finding that the company, defaulted or didn't do their subcontracting plan. You'd have to get your lawyer involved. You could be deposed. They can take you to the Court of Federal Claims or to the Board of Contract Appeals. So in reality, no one actually uses that, or at least I haven't seen it. You may have seen it once or twice, but I've never seen it.
I do think that these rules are going to create a different atmosphere with respect to negotiations between primes and subs with respect to both the teaming agreement and the subcontract arrangement. And if I'm a prime, I'm going to make sure that I am very clear with respect to what the subcontractor's liability is going to be. So if you make a misrepresentation, I'm going to protect myself, and I'm going to make it very clear that that misrepresentation is going to result in your liability, and you are going to be liable for basically the value of the subcontract, because that is really one of the draconian things that's in this new law with respect to what's the value of the misrepresentation to the government. What's the value? The value is basically the price of the value of the subcontract. So I think I'm going to make it very clear if I'm the prime, you're picking up that tab. Also, this contract, the subcontract, is terminated immediately for default. I think those things have to be very clear with respect to where the liability is. And if you're the prime, you're going to make sure it's with the subcontractor. And so I think it's going to be a new day with respect to what these agreements say. And I'm not sure with respect to the agreements that currently are in force. For example, I know a lot of teaming agreements always say things like, hey, you're not talking to the government, okay? I mean, no privity of contract. You, the subcontractor, cannot talk to the government. I'm not sure to what extent that's enforceable once these rules go into effect, and they are incorporated in the FAR, for example. I'm not sure if you're going to be able to enforce pre-existing agreements and the provisions that are in pre-existing agreements.
Question.
So it sounds like it's a done deal. This is happening. Is that correct?
The rules are in effect.
Okay. So it's too late to say change the rule because it's going to cause a million problems, because I think we all know it will to some degree. I'm not sure that it's going to give you the kind of return you're looking for. I think it's going to give our customers who don't want to talk to our teammates headaches. It's going to pull us into all sorts of more complicated negotiations, from the TA to the sub-K to God knows what, and it's going to shift our focus away from giving the government the right value, because oftentimes the reason we don't use a sub is because they can't deliver. They either can't deliver the right people, the right resources, the right price at the right time, or some other reason. So since it's a done deal, my question is, every one of us, whether we're large or small, are going to be a prime. Okay? So you have small business primes that are going to have small businesses on their team. Okay? So this is going to be a collective challenge for everyone. And my question is, how do you then as a prime, and I think you touched on it at the beginning, you said communicate out. So if I'm a prime right now and I see a problem on my team, is the best practice that you're recommending that I immediately notify you, show you the paper trail of all the back and forth, the million reasons why this small business is not in the best interest of the government, so that when they go and report to you, I'm somewhat protected?
Yeah,
So what do we do now is sort of my question.
Yeah, I think, remember, it's basically, it's a statutory provision for one thing, so, the comment period is kind of done with respect to that. You'd have to change the law. Now, there will be a comment period when it's implemented in the FAR. Maybe you can submit comments. They'll do a proposed rule and get public comments, and maybe you can submit comments to try to shape it at that point. But again, I think it's a requirement to tell the government that you're not going to use them. It doesn't mean that the government's going to not accept your explanation. Yeah, they may very well. I know if I was, as a government employee, that the contracting officers do not want to be involved in this, but it's really out of their control.
There's another little subtlety that you could address, and that is with regard to this size issue. Recently in the Washington Post, there was an article. You want to address that, Rob? Because that's pretty interesting in this.
Well, it's very interesting, and I have some strong views on this. The affiliation rules are just very complex. They are very difficult. No one really understands them. I'm very sympathetic to small businesses who actually make honest representations to the government with respect to their size, because they simply do not understand the affiliation rules. I don't know that SBA does. I mean, SBA, I noticed, disagrees among themselves. I mean, the Washington Post article was very interesting about what is affiliation, what are those rules. As one arm of SBA said, oh yeah, there's affiliation here. The other arm of SBA, the Office of Hearing and Appeals, said, no, there's no affiliation here. So SBA itself, different components within SBA don't seem to agree on what the affiliation rules are. So I'm not sure how small businesses are supposed to figure this out. But I do know they had better be real careful with these new rules and representations. We have a number of clients that are just absolutely paranoid now about this, and they do have affiliation arrangements, and the question is, are you still small? Are you small? Because of these particular arrangements, it is sometimes not clear. And as I point out, even the government's not sure when you're affiliated and when you're not. But you see the risk you have when you make a representation as a small business to the government that you say, I am small. I'm even using the term strict liability because, I think, in effect, as soon as you submit that offer to the government and you say you're small, that, even though you may have made a mistake, boy, good luck, because it's viewed as an intentional representation to the government, and if it's wrong, boy, you're going to have the burden of proof to show, wow, this is why it's wrong. And in this regard, I really think it's important for small businesses to go the extra mile in everything you do with respect to making sure you have a good record to show that you tried to do the right thing. When it comes to suspension debarment, when it comes to some of these other issues where the government can be quite harsh, it is always helpful to have some history and some record to show you did try, for example, to correct the misrepresentation as soon as you realized that there might have been a misrepresentation. You did everything in a timely way to try to correct that misrepresentation. You told the prime, you told the government, whatever. And you must have internal controls in place. You know, a lot of small businesses, when I moved to the private sector, I was really somewhat stunned that they viewed ethics programs and so forth as a nice thing to do. But look, we don't really have the resources, okay? So this is down on the totem pole of things that we are really going to expend resources on. I'm telling you, this is not a good idea. This should be number one, internal controls, ethics, and so forth. These rules, you need to show that you are doing everything you can to comply and that you have systems in place to try to verify and ensure that you represent your size and your status correctly. HubZone is certainly an example where, wow, that changes on a weekly basis with respect to whether you are still a HubZone contractor or not. And that's another area where Congress is looking very closely at the representations that contractors make. So there's so much risk here for both prime contractors and subcontractors, large contractors and small. And it's interesting to note, too, how many people really don't know what is in these rules. You know, I have also been struck by the fact that there is enormous ignorance out there with respect to how these rules are very significant, and it's a huge paradigm shift. And it's a good thing, I think, that your folks are talking about it today here. You know,
Rob talks about affiliation. So an example of it that was given the other day is, you know, you could be a small business, controlling interest over 50% of a small business, you're the controller, and you just happen to put yourself on the board of a large business. You now have an affiliation. You have to be careful.
This is a great one. Another example, and this is very practical, we all deal with it day in and day out. You bring in a couple temps, and all of a sudden your numbers go up over the significant number, and now all of a sudden you're not a small business anymore. And so, you know, really keeping track of how many employees you have at a given point in time and when you're making the certifications in relation to that. A lot of practical issues related to these.
Another question?
Yes, my name is Bill Cohen. A lot of times we put the teaming agreement in place, we do the proposal and submit the proposal, and then the government, they're taking longer and longer to make awards. And then upon award, we'll enter into a subcontract with our teammates. If in that period of time, we're seeing some contracts taking a year plus to award, do we have to recertify our teammates then before we enter the subcontracts? And then also, if we choose not to enter a subcontract with somebody we just had a teaming agreement with, because there was also a recent court ruling, I believe, basically said a teaming agreement is just an agreement to have an agreement in Virginia. So how does all of that play with these rules? Because there could be different, at what point is it I'm signed to this small business and I'm stuck with them? Or when can I choose to end the relationship?
Well, remember, I mean, again, it's not that you're stuck with them. You just have to notify the government that this... We tried to define what it means to be used to prepare a bid and proposal. We asked for comments. We have various things that we say in there, that they prepared parts of the proposal and those kind of things. It's not enough that they just called you or that you got a quote from them. It has to be something more. We had to define it in a way that it was something more substantial than that. But again, it's basically your proposal. If you somehow said that if they helped you in any way to do that bid or proposal and you don't use them, you just have to notify the government. Again, you can have an explanation as to why, and most COs are probably going to accept that at face value. I don't know that they want to get involved in these subprime disputes, but it's a requirement. The notice is there, and it's for they're supposed to consider it for purposes of past performance, really.
Another question back there. Don.
I have two small questions. The first is a little bit of a follow-up on something you just brought up, where you have a situation in which you bring on a few more resources for a shorter period of time. How does that affect your reporting status to the government? Do you have to report that if it's a sufficiently short a period of time? And then also, how does this set of rules affect relationships between subcontractors and then other companies that they may themselves subcontract the work to? How broad are these rules and how deep does it go?
That's a good question. The first one was the employee situation. I mean, as you know, we have size standards that are based on revenue for services and construction, and then for most manufacturing thing, it's based on employees. And we determine your size based on the date of your offer, the day you submit your bid. So that's what we're looking for, and we include all your employees, temps, part-time, whatever, when we're doing a size determination. So it's one day, that day you submitted your offer. What was the second question? I think the rule applies basically to a prime and their subs. It's not written in a way that it applies to a sub and their subs and so forth. I mean, this was very high-level prime. This is a contract where there has to be a subcontracting plan and so forth. So I don't know that we say it didn't apply, but it was not written or intended in that way. Yeah. And I would think that it does.
Yeah, there are oftentimes a small contractor will subcontract with a large contractor, to get some work done. So that's a subtlety. There was another one. Lisa?
I was just going to ask, you're on, I think, 9 contracting for small business. What about the consistency?
What about the consistency of the different schedules? One being 14 million, another being 25 million, another 35. Is there going to be some kind of parity with that as well, too? Because you describe small businesses in every which way.
Yeah, it's interesting you bring that up. We did, there are over maybe 1,100 different NAICS codes, and each one of those has a size standard. We did propose, SBA did, to kind of, instead of having a small business be large for one industry, and if the CO picks another NAICS, now they're not small, and depending on what code is picked, the size of the firm changed. We did propose to kind of try to bring them together. We got a lot of backlash, though. A lot of firms in those industries didn't want us to combine them, and Congress, in fact, passed something in the NDAA that says we shouldn't do that. So basically now we have to just examine the economic characteristics of each industry and set the best size standard that we can come up with. So even though I agree we wanted to go that way, we kind of got slapped down on going that way.
Rob, any other thoughts on that?
Actually, not on that particular question, but I do want to make the point with respect to the final rule seems to really suggest that primes have to engage in due diligence to ensure that the representations that they are receiving are accurate. I mean, this is, again, a huge paradigm shift. Our whole procurement system has really been based on self-certification. I mean, the government is trusting, and prime contractors, accordingly, were very trusting of the representations made. I think that is no longer the case with these rules. And so now we have primes, and again, I'm emphasizing here the responsibility of the primes to do due diligence to ensure, and really it's unclear what that really means. What is a good faith effort to ensure that the representation that was made by your small subcontractor really is correct? And the rules suggest the prime looking at the internal controls, looking at the internal management processes and procedures that subcontractor has in place for ensuring the veracity of its size and status. And so you almost, as a prime now, I think, to really be risk-free, there's no such thing as risk-free, but to lower your risk, you really got to take a look at that subcontractor's internal systems and management systems. And I think that's a huge, it's obviously a significant burden, but I think it's here.
Another question?
You made the comment about the size determination being on the date of submission. Will we have to get to the point where, like, if a year later the government comes back and requests additional information, say your BAFO, is it that date? Because a year later, your sub may not be small anymore.
Yeah, that's a good question. As far when I'm talking about the date of your offer, I think the same rules would apply for I guess your subcontract. But I was talking about a prime contract context, and it is the date of your offer, and we did make sure that it's that date, and that we don't want a year. I know the government can take a year or more to award a contract. We don't want you to be declared ineligible a year later because the government took so long, and we don't want the government to lose out on the bid they're trying, the contract they're trying to award because it took so long to award the contract. So we stick to the date of initial offer, including price, for prime contracts.
But it might be helpful to address the continuing obligation that contractors now have to update at time of option and so forth. I mean, basically every year you're going to have to be doing something with respect to certification, representation, and so that's an additional burden on small businesses to make sure, at least on an annual basis, pretty much, that they got to make sure that they really are giving the correct size and status representations.
Right. We did have to come up with a recertification rule when Rob was at the OFPP because these contracts were going 20 years and these firms were being bought by large companies and it's always going to small and people couldn't figure out why that was the case. So we do basically say for long-term contracts, prior to the 6th year, you got to recertify your size, and if you're acquired or merged, you have to recertify to the government your size, and then basically that changed the counting for the government from small to large. Is what it does. There's no requirement that they don't use you anymore or not exercise the option, although the government could do that if that's what they choose to do.
Yeah, I think one of the subtleties of these rules is the communications that is discussed. The communications between the subcontractors, now a small subcontractor, and the customer, in that if a subcontractor is doing a really good job, now they can market to the prime, to the government directly, and talk the government into giving them, hey, let's eliminate the prime contractor and give me a prime contract. It's one of the marketing subtleties of these rules. One over there.
Hi, I just want to know, where can we get a copy of the rules so we can read them? You have them? My man.
Yeah. I have them here, and you can take a look down and see where they are and write them down.
Yeah, Jim, I'll make a prediction.
Yeah, I should have put them in there. Oh, is it? Oh, we put them in there. Oh, okay. It's in the program. I didn't even read the program.
Jim, I'm going to make a prediction for you because in light of the Washington Post expose that was last week, there are going to be congressional hearings into the rules, the application, especially the affiliation rules. And so I think there are more rules to come. I think that Congress will do something else with respect to ensuring accountability in this whole area. So I predict that you're going to see probably clarifications with respect to the affiliation rules, maybe more stringent application of what constitutes an affiliation. The problem, and the reason we have the rules and just putting my former government hat on, the reason we have the rules here today, and we can debate whether they're good or bad, but they're here today because there were people that abused the system, and everybody eventually pays for that, even though you may be totally honest and you do everything perfectly, you are going to have increased burden and costs because other people did not have the same standards that you have. And that's going to happen because of the Washington Post articles last week, I can guarantee you. And it's going to be just more difficult. And I think but the government had to do something because there was enormous misrepresentation. Arguably some of it was intentional misrepresentation with respect to size status. And it's just the government had to respond. Congress had to respond in some way. The prime contractors' failure to adhere to subcontracting plans, that was an ongoing problem. Again, there has to be some type of response from the government and some type of accountability. So what Congress did and what SBA did, at least the motivation for it was justifiable, and there's no question about that. I mean, we will get into the weeds with respect to how it's being implemented and what this means and what that means, but I do think you have to appreciate the fact that the government had to respond to the growing criticisms, and I think that there's going to be further response because of that Washington Post article. I mean, I was quite taken back by the length of that 2 days in a row front page. I mean, that gets attention, and already Congressman Issa has obviously read the articles.
So can you talk a little bit about how this is being rolled out across the government to contracting officers so that they know what their new responsibilities are?
Well, basically, when the Jobs Act was passed in 2010, we went around the country and held open forums like this with not just small business subcontractors, large businesses as well, and contracting personnel. Got a lot of input. Now, basically, the process is our rules are final. They've been sent to the FAR Council, and the FAR Council is working on what they call a straw man, a section-by-section breakdown of where the sections have to be changed and where, what needs to be implemented. And so once they're done with that, they'll do a proposed rule. They'll have a preamble where they say what they're doing and what parts of the FAR they're proposing to change, and at that point it's open for public comment. All these rules are issued in the Federal Register for public comment. Usually it's 60 days, sometimes longer. And you can go, is it regulations.gov, I believe, where you can go and submit comments online to any of these rules. And each one of these will be implemented at a different time. I think the multiple award contracting and subcontracting ones will be implemented more quickly than the size and status rule, but that's just a guess.
Thank you.
I will say I think the prime contractors lucked out in one respect with respect to the burden that's placed on them. With respect to the subcontracting plans and the alleged lack of adherence, to those plans by the prime, it's not that really that big of a deal. I mean, the prime contractor just has to notify in writing the government why they've decided not to use a particular subcontractor that they said they were going to use, why they are not meeting the small business goals that they put in their subcontracting plan. I don't think that's unreasonable. I mean, as far as letting the government know why. The challenge will be make sure your why is reads well. That it is definitely well thought out and passes the straight face test. As long as that's the case, I think that prime contractors will be fine with respect to, they'll still have an enormous amount of flexibility with respect to which subcontractors they use and whether or not they make those small business goals that they announce to the government in their subcontracting plan.
I'm sure it also have to be part of the CPSR process that you're going through as well to be able to justify what you're doing in each of these areas, because it'll have an impact there as well.
Jim?
Just a quick question, and thank you all for being here. Is there going to be some sort of a data collection effort imposed on contracting officers to try and track how many times they get these requests, how many times, something about these new changes that they have to take action? Are you going to be asking how many times did a subcontractor appeal to you? Do you have to report it somewhere?
Yeah, I think that's something when we implement in the FAR, we'll have to instruct contracting officers, not just how they consider it, but where they enter that information. And for example, the requirement to, or the ability of the CO to report someone in FAPIS of having a history of late payments. We try to define that as, I think, 3 late payments within a 12-month period. And again, that's 90 days late. The sub is performed adequately and you've been paid. These are not situations where you have a dispute, the sub didn't perform, so you're not going to pay them. This is a clear-cut situation where you've been paid by the government, the sub's performed, and you haven't paid them in 90 days. If you have a history of that, you can be reported in FAPIS, and then COs will consider that the next time they come up to make an award to that particular project.
But to monitor the activity under the rule changes, every time a CO gets such a call, should they have to enter the fact that there was a call so you understand how much activity took place?
Yeah, it remains to be seen whether that's something that we have to collect data on. Is it something that's in the contract file? We'll have to see how we implement that in the FAR, and then specific instructions to the CO.
You may want to ask.
Very burdensome.
Yeah, very burdensome.
Yeah.
These rules, certainly, Jim, will be some self-policing on this for sure. But you're saying the frequency of that could cause a real pain for a contracting officer. Was there another question? Well, I think that this was really interesting. Rob mentioned that this is a paradigm shift. There's no doubt about it. These rules are significant. Once they're incorporated in the FAR, we'll all have to deal with them. We have to deal with them today. And it is a big change. Any other wrap-up comments, Ken?
I think we have one more question.
Oh, sorry. I'm sorry, Dan.
This is more of a comment than a question. So like Rob, I have a former OMB hat. And the FAR process that you described that's going through, back to the question earlier, I think it was Daphne that asked me, there's still opportunity to comment with the FAR process. And through those comments, the government might make decisions to modify the FAR process. It might get into discussions with SBA about whether there's an opportunity to address unintended consequences by making amendments to the rule. So those, the comments that we heard today, I think would be good to continue to be thoughtful within our companies about how to express those through those processes, because corrections and improvements can continue to be made.
I was glad that ACT-IAC had the opportunity to at least present this. Let me give 2 big thank yous. First to Mary Ann to coming out of the audience and coming out. And then Ken and Rob for coming downtown and being here today. I really appreciate it.